case briefs, and so much more. LSData's got what you're looking for.
In 2001, the Supreme Court held in Circuit City Stores, Inc. v. Adams that the exclusion provision in the Federal Arbitration Act, FAA, should be narrowly interpreted to apply only to transportation workers. The case stemmed from an employment dispute between Adams, the plaintiff, and Circuit City. When Adams signed his employment agreement, it included a binding arbitration provision. However, upon alleging employment discrimination, Circuit City argued that under the FAA, the case should be settled through arbitration rather than litigation. Adams challenged this argument, contending that as a transportation worker, he was excluded from the FAA's arbitration clause enforcement. The district court sided with Circuit City, but the appeals court disagreed, prompting the case to be brought before the Supreme Court. Justice Kennedy wrote the majority opinion, applying the statutory construction canon of ejusdem generis, which states that general terms should be interpreted to fit the theme of the specific terms that preceded them. Consequently, the court found that the exemption in the FAA only applied to transportation workers. As Adams did not fit into any of the excluded categories, the Supreme Court ruled that he was required to pursue his employment discrimination claim against Circuit City through arbitration, as dictated by his employment contract.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.